Please be seated. Morning, council. Court now calls case number CV130255, Investors versus Arrowhead et al. Council, this is the time set for oral argument. These proceedings are audio and video recorded. Let me advise you that there's a link to these proceedings, and they will be available on the court's website within a few days. In fact, the video may be available on YouTube. Please identify yourself and your client before you commence your argument. As you both know, you each have 20 minutes. Counsel for appellant, you can reserve some time for rebuttal if you wish. Keep in mind, we have read the briefs, we've conferenced the case, we've discussed it, so we're very familiar with the case. And the last thing I would admonish you is you have a clock up at the podium to help you keep track of time. Counsel?
Thank you. Good morning. My name is Melissa Iyer, and I represent the appellants. I'd like to reserve about 5 minutes of my time for rebuttal, if I may. Before reaching the specific issues, I'd like to start by emphasizing that this is and always was intended to be a non-recourse loan. If you look to paragraph 13 of the promissory note, you'll see that the original lender in this case, Transamerica, promised, and I quote, not to enforce any monetary judgment against the borrower except by recourse to the collateral and pursuant to the carve-out obligations. What we have in this case is several years later, a successor lender coming in, offering a new interpretation of the loan documents that renders that promise essentially illusory, and turning this non-recourse loan essentially into a full recourse loan. And it is within that context that I ask the court to look at the issues presented pursuant to the specific guarantees. The resolution of this appeal centers on three primary issues. The first issue is whether or not the fair market value determination required by Section 33-814A and C can be prospectively waived. I think that we've addressed that issue fairly extensively in the briefs, and that the court's recent decision in CSA 13 Loop 101 is dispositive of it, so I won't spend any time on it unless the court has any specific questions. The second issue relates to whether or not the personal guarantee signed by guarantors Bagato and Volk expired before any material default under the terms of the loan, so that it is no longer enforceable in these proceedings.
Now, counsel, where did that number come from for the personal guarantee of $350,000?
It's in item 15, Exhibit D, which is
I know it's in the papers, but what does that number signify?
It is a cap on the liability of the personal guarantee.
I know that
for the
too,
first.
but I'm just talking about the number. How did you arrive at $350,000? Something real, or is it just a negotiated item?
I think it was just a negotiated value to guarantee payment during the first 60 loan months as set forth in the guarantee for the first 5 years of the loan, while monthly payments of principal and interest were being made. There was also the additional separate carve-out guarantee that's common in non-recourse commercial loans, often referred to as a bad boy guarantee, where only certain items set forth in the carve-out obligations would be subject to liability post-foreclosure. And so what we're dealing with in this case is the enforcement of both of those guarantees and whether or not they can be enforced based on the facts set forth in the record. I'll address first the issue of the personal guarantee.
Now, before you get to that, the way this is structured, you basically got 59 installment payments and then a big payment, right? A balloon payment?
Yes, Your Honor.
And it's my understanding that a lot of times these kinds of transactions are structured such that the installment payments basically are interest payments. Is that the case here, or did the installment payments actually reduce the principal somewhat also?
The installment payments actually did reduce the principal. If you look at the promissory note, it was amortized based on a 23-year amortization schedule, which is set forth in paragraph 2 of the promissory note. That the payment schedule is set forth there. The loan closed on December 2nd, 2004, and pursuant to that paragraph of the note, the first payment came out of closing was technically an interest-only payment of accrued interest through December 31, 2004. Then the first monthly payment would be principal and interest in arrears amortized for the payment amount was based on 23 years, but obviously the loan itself was only for 5 years, so that whatever remained at the end of that, after the 60, or actually it was the 60th payment, you would have the balloon payment due, which would be principal and accrued interest and any other amounts. And so that structure is what you really need to look at when you're in determining how to interpret whether or not the personal guarantee for $350,000 expired prior to the default in the payment of that large balloon payment on December 1st, 2009.
And getting back to your broad theme for a moment, are you suggesting that the appellees seek to exceed the cap?
Well, I think that based upon the interpretation that they've provided for in the documents and that the trial court adopted, they have exceeded the cap. Because what they've done is, from our perspective, if you interpret the loan documents within the overall structure, you have a $350,000 guarantee that covers the monthly payments. Then you have recourse to the property and the carve-out obligations. Well, in this case, there currently is a judgment against the guarantors for in the amount of the $350,000 cap, plus the carve-out obligations and default interest on all of that amount, which at this point has accrued to almost $1 million.
But how does that exceed the cap globally? I mean, if that's what the documents contemplated, I don't see how that renders any promise illusory. Leaving aside for a moment whether some of your arguments about this liability attaching on these facts work, let's assume that you were to lose all those. What promise does that render illusory?
I think it renders the promise that the obligations would be limited to what's specified in the loan documents. The guarantors were looking at their loan documents, believing that they were guaranteeing payment up to $350 for the 60 months, and then that, assuming they couldn't make that balloon payment, they would only be liable if there were specific carve-out obligations, actual losses arising out of the carve-outs. And now they're faced with an interpretation and a result that makes them liable for the $350,000, notwithstanding the expiration they expected, and notwithstanding the fact that each and every one of those payments over the course of 5 years were made.
But, Counselor, the papers included a language that the guarantors hereby unconditionally guarantee to the lender that all payment obligations of the borrower up to an aggregate total amount of $350,000 will be paid in the amounts and at the times and in the manner set forth in the loan documents. It says it's a guarantee of all payment obligations. And so don't we have to read the expiration date consistently with that, and which would suggest that the term of the guarantee covers the term of the loan, including the balloon payment?
Well, I would suggest, though, that reading that unconditional guarantee of the obligation for $350,000, in order to read that consistently with the concept of an expiration, it would be inconsistent to hold that the guarantee survived through the maturity date. Because there's simply...
isn't the expiration just meant to mean that if there's an extension of the loan or renegotiation of the loan, that any guarantee would have to be also renegotiated? Isn't that the point of the expiration date?
Well, I would disagree that that's anywhere within the terms of the guarantee. All the guarantee says is within the first 60 loan months, if there's no default, then the guarantee will expire. And so to read that expiration as having some purpose, it has to be limited to the monthly installment payments and not extending into a maturity date. Because really, if you're interpreting the provision requiring an unconditional guarantee as extending into the maturity date, really for the life of the loan, then there is virtually no expiration of the guarantee at all, regardless.
But on the other hand, if you wanted to write a guarantee that expired magically one day before the most likely event of default, this is an awfully opaque way to write it, isn't it?
It is, but if to the extent that it was written, obviously it was written by the lender, and the rules of construction, to the extent it has to be construed, are to construe it to strictly limit the liability of the guarantor. So to the extent the court is looking to reconcile those provisions, the interpretation that should be adopted based on that rule of construction is to limit the liability of the guarantor, which would mean limiting it to the 60 months of installment payments beginning December and ending November 2009. And that's consistent with the non-recourse nature of the loan and the separate carve-out guarantee that these same guarantors signed, believing that upon a default and foreclosure, that would be their guarantee obligation.
You're saying there were 60 installment payments plus the balloon payment?
There was 59 installment payments of principal and interest. In December of 2004, when the loan closed, if you look at the paragraph 2 of the
Interest only
right.
Subtraction or something.
Right. And so together, the only sensible way to read that provision is that the first loan month is when the loan closed, December of 2004. The 60th loan month then becomes November of 2009. And I would submit to you, if you think about the fact that if this loan had been extended, when would the guarantee have expired? It would have expired on that last payment in November of 2009. The same expiration as if the loan is not extended, because that was the time period that they guaranteed. They did not guarantee the maturity balance of this loan. That was something that the lender, the original lender in this case, promised would be non-recourse, would be only their only resort would be to the collateral and the carve-out obligations, which is why they also made these same guarantors sign the separate carve-out guarantee, guaranteeing to repay those carve-out obligations in the event that they arose. And so, for that reason, the sensible way to reconcile all of the loan documents, the promissory note, the deed of trust, the personal guarantee, along with the separate carve-out guarantee, and harmonize the provisions of all of those documents, is to find that the guarantee, the 60th loan month, was November of 2009, and that the guarantee in this case, because there was no default as of November 30th, 2009, the guarantee expired and it cannot be enforced based upon the default that occurred as of December 2nd, 2009. Now, with respect to, the lender argues that even if you accept our premise that the 60th loan month was December 2009, or was November of 2009, that there still would be an extension of liability on the guarantee based upon 3 late payments that were made by the property management company in 2005, 2008, 2009. We think that the state of the law in Arizona is fairly clear that when the lender, as they did here, accepts a late payment, accepts significant consideration for that late payment in the form of thousands of dollars of late fees, they waive the default, and the default is extinguished as a matter of law. They can't, as the court said in Madison Avenue versus Madison Bentley, revive the default for purposes after the fact of triggering or extending guarantee liability. They've given up or relinquished that right. It has been waived. And so for that reason, the lender's reliance on those late payments, when in fact, if you look at the documents, you'll find in items 22 of the record, exhibits 5, 6, and 11, that the lender not only accepted the payments, they invited the cure. You'll see an email dated August 14th, 2009, where Jen Henderson of the servicing company Aegon sent an email over to Arrowhead's management company saying, hey, I noticed you guys hadn't made that payment. Probably wasn't a simple oversight. Just wanted to give you a heads up. So obviously, Arrowhead cured that default, brought the payment current, paid the substantial late fee, and continued to perform on that loan without any acceleration, without any default interest. And so the lender's reliance on the three late payments over the course of 5 years and millions of dollars of payments is misplaced. Next, I'll discuss the liability set forth in the carve-out obligations. It's important to look at the language of the carve-outs, which only suggests liability can be incurred for actual losses arising out of the carve-outs. They've made claims for 3 alleged losses arising out of carve-outs: misappropriated tenant security deposits, unpaid property taxes, and expenses incurred in connection with the foreclosure. Based upon the plain language of the carve-outs, summary judgment on those claims was completely improper. First, there was never any evidence of misappropriation of tenant security deposits. The assignment of rents gave the borrower the ability to use tenant security deposits in the operation of its business. As long as that license was in effect, it was not a violation of the contract or of the law for them to do so. Misappropriation, as that plain meaning of that term, is theft. Yet there is nothing in the record that the lender can point to that these monies were stolen. So in that regard, there is no evidence that tenant security deposits were misappropriated, and summary judgment should have been granted to the defense. As to the unpaid property taxes, this is another example of the lender engaging in conduct intended to maximize liability, despite there being no actual loss for unpaid property taxes. At the end of 2009, when the default occurred, there was $73,000 in escrow for the payment of taxes. The receiver, who took over at the insistence and for the benefit of the lender, nevertheless paid Arrowhead's taxes without objection from the lender out of Arrowhead's operating account. So the lender allowed that payment to occur, but then nevertheless, after the foreclosure sale, decided instead of using that money for taxes, it was going to pay itself back and then pay 2010 taxes out of a different account to create carve-out liability. That is not an actual loss, it's a manufactured loss, and it should not have given rise to carve-out liability for unpaid property taxes, particularly when, as here, if the lender had accepted the deed in lieu that was offered in 2009, there would have been no 2010 taxes incurred by Arrowhead at all, which leads me to my final point. The trial court awarded over $47,000 to the lender for expenses incurred in connection with the foreclosure, even though the record is replete with evidence that the borrower offered to provide them with a deed in lieu of foreclosure in December of 2009. The lender rejected that and instead opted to pursue a receivership. The provision of the contract says the borrower or the carve-out obligors are not obligated unless or in the event that they offer a deed in lieu or the lender's choice of an uncontested foreclosure.
Counsel, what I have is an email from Arrowhead's lawyer that said, my client would like to keep the property if it can get an extension of the loan, but if the lender wants the property back, there should be no obstacle to a deed in lieu, thus making the receivership a needless expense. I mean, it's kind of a highly contingent offer, isn't it?
That's one of the points made, but I don't think it's contingent at all to inform opposing counsel that the receivership is a, quote, needless expense. And then if you look again to a later email, he says, again, this is a needless expense. But it's your client's money. We will cooperate in whatever your choice is. And so you'll see from the record that Arrowhead did, in fact, stipulate to the appointment of a receiver in what essentially was an uncontested foreclosure. So the trial court erred in finding that Arrowhead was liable for out-of-pocket expenses incurred in connection with the trustee's sale. And I'll reserve the rest of my time for rebuttal.
All right, thank you, counsel. Mr. Palmer?
May it please the court. Good morning. My name is Brian Palmer. I am counsel for Appley Investors Warranty of America, Inc. I think what you have here is a simple breach of contract action. You've got two sets of sophisticated commercial parties represented by counsel negotiating at arm's length to enter into a commercial transaction. And they meticulously documented the terms of that contract in the loan documents, and those documents are clear. And with respect to every single issue that appellates contested below and contest here today, they're resolved by the loan documents, and they're resolved in favor of the appellee. That goes with respect to the $350,000 guarantee, whose continuing liability was triggered by the various defaults that occurred within the loan term. It goes to the carve-out guarantor's liability for the borrower's misappropriation of security deposits, failure to pay property taxes, and for the expenses to enforce the loan documents in the wake of the borrower's default. And it also goes, that same statement applies with respect to the agreements that the appellants freely entered into with respect to the waiver of their 33814A rights. Now, appellee understands that the CSA Loop 101 case has a lot to say about the enforceability of those provisions, but nonetheless, they freely agreed, appellants did, represented by counsel, to give up their rights to that hearing, and they did it for, as they acknowledge in the loan documents, a benefit. And we would, appellee would respectfully request that this court reconsider Loop 101 for reasons that I'll get into momentarily with the court's permission, because appellee believes that a different result should have been reached, and a different result should be reached here. But with that, I would like to save that for the end and talk a little bit about some of the other issues here.
Can you enlighten me about this, the number of $350,000? Is that just an amount that the lender thought was large enough to protect the lender against a diminution in the value of the property in the case they had to take it back?
Unfortunately, Judge Thompson, I cannot, I don't have that information as to why the 300.
It doesn't relate to anything out there, does it? I mean,
not that I'm aware of, but it seems to me that it was, as was pointed out by the panel, a negotiated term by commercially sophisticated parties. Maybe it has something to do with the waiver of the 33814 rights, maybe not. I don't know. But the short answer to your question is I can't help you out there, Judge Thompson.
What about the expiration, though? It sounds like the interpretation you're advancing with regard to the 60-month expiration essentially renders the expiration illusory. In other words, there are no defaults that could occur that would ever make that expiration of the guarantee benefit the guarantors under your interpretation, right? Because all defaults all possible defaults would have to occur within the time of the expiration. So I even have an expiration.
Well, I think the loan documents themselves, Judge Swan, actually speak to that, and it's and actually some of the cases that appellants cite deal with this very situation. When you have a document that is secured by a guarantee and the term expires, the guarantors don't want to be left on the hook for that extended term that may be renegotiated, in this instance, between the borrower and the lender.
Well, but if there's going to be a renegotiation, it doesn't read to me like it was like the parties were planning for a renegotiation. And if there's going to be a renegotiation, they can always renegotiate the duration of the guarantee. So I'm still trying to understand why have a deadline if your reading is correct and the guarantee is going to cover every conceivable default under the life of the loan anyway.
Well, I think that the purpose of the guarantee was to secure those 60 payments.
Well, of course, but again, the question here is not the monthly payments, but whether in the event of the most likely default, which is the failure to make the balloon payment, the guarantee is still alive. We have arguably ambiguous language. We have an interpretation that says the guarantee expired before that balloon payment was due, and one saying that it expired after the balloon payment was due, right?
That's correct.
If the interpretation saying that the guarantee expired after the balloon payment was due is correct, then the expiration date serves essentially no practical purpose that I can discern.
Well, Your Honor, I would argue that the reason the very reason that you just stated, that this last payment was the most likely payment there was going to be a default on. Of course, the lender would want to guarantee that payment. And again,
Well, I'm not. Of course, the lender wants as much money as it can get. I get that. But why write a provision that is meaningless? Our canons of construction generally direct us to construe documents in a way that prevents a provision from being meneningless.
well, I don't think the provision is meaningless, Your Honor.
Okay, when does it kick in under your interpretation?
Again, I think the purpose goes to protecting the guarantors in the event that there is some sort of an extension of the loan term. And there were no negotiations. In fact, the borrower was pushing heavily for a loan extension.
So it's just doing a little legal work in advance in case they renegotiate, they've already got part of the renegotiation written? That's the theory?
Well, I would think that you don't want a situation where there is an extension and nobody says anything about it, and then all of a sudden the guarantors are thinking, well, we don't have to, the 60-month term is ended, we don't have any liability, and then all of a sudden you have arguments made down the line when there's a default, because the guarantee...
In the event of this hypothetical renegotiation, the lender can always say, guess what, we're not renegotiating unless you extend the guarantee, unless the guarantee is present. But it seems odd to contemplate a very specific loan term. There's no mention of renegotiation in the original documents, and have a time limitation on a guarantee that can never practically be invoked. Why write it?
Well, I think the appellants themselves in their briefing said that everybody contemplated that there was going to be an extension. And so I think, again, that's the answer, Your Honor, Judge Swan, that it was to preserve the guarantee. And with respect to the term, the guarantee's terms are pretty clear. It talks about a 60-month loan term. And if you look at the restated note, you need to go really no further than the restated note. It speaks of 59 monthly payments and then a 60th maturity payment that's set to occur on December 1st, 2009. So you've got 59 monthly payment, or you've got 60 monthly payments, and you've got 60 loan months. So the loan term in the guarantee is identical to the loan term in the restated note. And they want to argue it ends on November 30th, 2009, which would actually place the maturity date in a 61st month that's not mentioned anywhere in the loan documents. I think they know they have problems with this, because then they move on and they say, well, even if the failure to make the 60th loan payment occurred within the loan term, there's still no default in the loan term. And again, as Judge Thompson pointed out, if you look at the clear and plain language of the guarantee, it's guaranteeing all payment obligations. It's not guaranteeing most payment obligations, some payment obligations, all 59 obligations, but not the 60th, and as Judge Swan pointed out, the most substantial payment obligation. It's guaranteeing all of them, and it furthermore guarantees that they will occur in the time and in the manner set forth in the loan documents. Well, the loan documents say that there is to be a maturity payment that's to occur on December 1st, 2009. There was no payment made on December 1st, 2009. The default occurred within the loan term. And if that weren't enough, there are other defaults that the borrower committed with respect to its monthly payments, any one of which triggers continuing liability under the guarantee. The loan documents state that the borrower is in default if it fails to make a monthly payment within 10 days of the day that it's due. So there's a day that it's due, and then there's a 10-day grace period. And it's undisputed in the record that the borrower failed to make the payments within that grace period in March of 2005, in December of 2008, and August of 2009. And in August of 2009, the lender objected to the default, sent a notice of default, teeing up its acceleration remedies. And so clearly it didn't just sit on its hands and waive its rights here. And another important factor with respect to all of these defaults is that the loan documents speak of them occurring immediately. And with respect to monetary defaults, you don't need a cure period. They occur immediately as soon as there is a breach of the term of the loan. And that's exactly what happened here with respect to each one of these defaults. Appellants want to cite to this case out of the New York Court of Appeals, which was a split decision. That doesn't really help them here because the facts were different in that case. That case involved a guarantee of a lease that had expired, and the issue was whether the guarantee, there was some default that triggered continuing liability. There was no objection to the defaults. There was no notice of default, and all of the payments occurred within the grace period provided by the documents, and the court determined there was no default. That's a totally different situation than what we have here. And on the issue of the guarantees, appellants urge you to look at this as a non-recourse transaction. Well, the law is clear in Arizona. The loan might have been recourse, but the guarantee was not. It was capped at $350,000, and the law is clear on this. In Arizona, and as far as I know, all of the jurisdictions, the contract and the guarantee contract can contract for greater liability than that provided under the promissory note. So this is not a situation where we have a non-recourse transaction with respect to the guarantees and the carve-out guarantees. And I'll also note that appellants erroneously state that we had the same set of guarantors. That's not the case. There is actually an additional guarantor with respect to the carve-out guarantees. And there's nothing in the law that says that you can't have an unconditional guarantee and then also have a carve-out guarantee, and some of those obligations may overlap. Again, we're dealing with sophisticated commercial parties. Both sides had counsel when they were negotiating these documents. These documents are meticulous and detailed, and everybody knew what they were getting into here. So we have to assume that that everybody agreed to this, and there was no contract of adhesion here. Also, appellants urge a strict construction. We would urge, number one, that the guarantee is unambiguous, and in that case, there's no need for a strict construction. But even if you apply the doctrine of strict construction to the guarantee, at the end of the day, a guarantee it's a contract, and you try to interpret it in accordance with the parties' intentions when they entered into the contract. And again, it makes no sense to have a guarantee that guarantees 59 payments but not the 60th and final loan payment.
Well, if the 60th payment happens to be, tens of times greater than the 59th payment, there's a possible reason there, right? I mean, with all these counsel and all these sophisticated parties, you'd think somebody would have just said in plain English what happens in this most likely scenario.
Well, Your Honor, I would argue again and just reiterate that our position is that was the reason that was a term was it was done to protect the guarantors in case an extension was negotiated.
No, I think the point is in the University of Possibilities, you could have a contract where the agreement was, we want somebody to guarantee these installment payments, but we're willing to take our chances on the value of the property. We'll just take the property back if you don't make the balloon payment. I mean, that's possible. And so we can't assume that it was necessarily intended that the 60 months of the guarantee be coterminous with the 60 months of the loan. We have to look at the rest of it.
It's also pretty reasonable to assume that the guarantors would be much more willing to guarantee a manageable monthly payment than a huge balloon payment that exceeded their ability to pay.
Well, again, the plain terms of the guarantee state that they're guaranteeing all payment obligations under the loan documents that the borrower has to make, and they're guaranteeing the time and the manner of those payments. And I just want to say one thing about I won't say that.
Well, I just say, I mean, we don't have evidence of like commercial reasonability or commercial practices in this case. We're interpreting this as it's written and not up here wondering about how commercial practices work. We're going to interpret this contract the way it's written.
It's always a little dangerous when you have a comprehensive set of transactional documents and it takes the Court of Appeals to figure out what they mean. At that point, somebody hasn't written something very clearly, it sounds like.
Well, I would just say with respect to that, there is the revised loan commitment that clearly places, at least with respect to the maturity date, clearly places that within the 60-month loan term. And I know appellants are going to argue that that's not a loan document. It clearly is a loan document pursuant to the deed of trust, which is dated May 17, 2002. There were two different transactions here. There was a loan in May of 2002, then there was a refinance in December of 2004. The deed of trust defines a loan document as a document that evidences the loan, that's delivered in connection with the loan at closing or in the future. Clearly, the September 2004 revised loan commitment evidences the loan and is delivered in connection with the loan and was delivered in the future from the original deed of trust. The guarantee is replete with references to the loan documents and in fact states explicitly that the phrase loan documents will be interpreted as it's defined in the deed of trust. So I would instruct you to look there if there's any doubt as to whether the maturity date didn't fall within the loan term.
Now, we couldn't tell how the trial judge approached that, whether the trial judge considered it, believing it to be part of the loan documents, or did not consider it, concluding that it was parole evidence. I don't know if you know of something in the record that says what the trial judge thought about your last argument.
I do not, Your Honor, on that point. But I would like to quickly go to the carve-out guarantees if there are no further questions. With respect to the security deposits, the carve-out guarantee guarantees the borrower's misappropriation of the security deposits. And it's undisputed that on December 2nd, when the license to collect and use the rents was revoked, that there was in fact some $68,000 in missing security deposits that the borrower later admitted that it used for day-to-day operations of the business. Now they want to say, yeah, but Section 4 of the Assignment of Leases and Rents lets us use the rents for anything we deem that's not illegal. Well, the problem with that is that provision excludes security deposits and actually specifies that those funds are to be held in trust and for the benefit of the lender, and it's easy to see why that's the case. It's for the very reason that occurred here. The borrower defaults. You need to have a store of security deposits that have been preserved so that when the lender steps into the shoes of the borrower as the landlord, he has those security deposits to use pursuant to the terms of the lease. And well, they want to cite to the Section 5.1 and 5.2, which gives them a license with respect to leasing actions. In effect, gives them the ability to transact business as a landlord. Well, no one's arguing that license doesn't allow them to accept security deposits. No one is arguing that they don't get to use those security deposits pursuant to the terms of the lease. But what they cannot do, and there's nowhere in the documents that they can point to, is to say, well, but we get to use it for day-to-day operations. That's just not in the record. With respect to property taxes, any way you slice it, all they left us with when they defaulted was around $73,000. That wasn't even enough to cover the property taxes for the last half of 2009.
Well, it was within about $100 of being enough, and so I'm wondering why the payment from operating funds rather than from the amount in trust.
You know, I don't know the answer to that question, Your Honor, but
That's a pretty important. I mean, it hardly escapes notice that you're within less than $200 of the $74,000 tax obligation with the amount the borrowers had saved up for that, and then the receiver goes ahead and uses them for something else. Isn't that problematic?
I don't think so, Your Honor, because at the end of the day, there is nothing in the documents that absolves the borrower of liability to pay the property taxes for 2010. Now, if we had done what they said, or if we had done what they say the documents required us to do, if we had taken the money in the escrow fund, paid the last half of 2009, there would have been no money in the escrow fund to pay the property taxes for the first half of 2010.
But why is, I mean, I'm sorry if I'm just missing something obvious here, but property taxes are paid in arrears. The loan ended in 2009. Why are we talking about 2010?
Well, because the trustee sale didn't occur until May of 2010, and I don't think they can contest that. So and I think they've even argued that
The loan documents didn't obligate them to save up for the delay in conducting a trustee's sale. The loan documents obligated them to pay the property taxes in a timely manner, which in this case would have been '09 property taxes.
I see I'm about to run out of time.
We'll indulge you.
Again, and the loan documents specify that they pay the property taxes, and it's undisputed that there were no property taxes paid by the borrower for the first half of 2010 when they were legally still in possession of the property. In fact, they argue that the receiver steps into the shoes of the appellant. So that's the reason why they're liable for those property taxes.
Let's assume that they are liable because they were in possession in the first half of 2010. It still doesn't explain the accounting practice by which all the 2009 taxes were paid with operating revenues rather than the money held for that purpose.
Well, I think it's important to keep in mind there's two independent obligations here. The lender is entitled to have the borrower pay the property taxes, but it's also entitled to the rents upon default. So at the end of the day, no matter how you slice it, you pay. There's one pot of money, and there's two different payments that need to be made. And the pot of money that we were left with was insufficient to pay the amounts that were due and owing. And with respect there, I would just say that the loan documents control all the issues here, and that you should affirm the Superior Court's judgment. And if you're disinclined to reconsider Loop 101 and send us back down for a fair market value hearing, there's no reason to disturb the rest of that judgment, and including the Superior Court's judgment with respect to dismissal of the appellant's counter claim for unjust enrichment, which they don't contest on appeal. Thank you, Your Honors.
All right, thank you, counsel. Any other questions? All right, counsel?
Your Honor, with respect to the question you were just asking on the carve-out obligation for taxes, the opposing counsel pointed out that there's one pot of money and two obligations. The key, though, in this case is only one of those obligations gives rise to a carve-out liability, which is why the lender elected to create the liability when there wasn't really a loss. There was enough money to cover taxes for 2009, and that's what that money should have been used for, but it wasn't. Instead, the lender decided that it would pay itself back, is how it was described in the answer brief, for the rents it was owed, and instead pay taxes out of its own pocket to create a carve-out liability. Again, that's not an actual loss, it's a manufactured loss, and it is not covered. The carve-out obligations are only for actual losses, not fictitious ones. With respect to the demand and the waiver argument, the opposing counsel relies heavily on the fact that in August of 2009, a demand letter for payment was sent to the borrower. You'll find that demand at the record item 16, Exhibit M, which is the August 2009 notice, and when you read it, you'll find it isn't a notice of default so much as a demand for a cure. And again, following that letter, we have the email exchange at item 22, Exhibit 11, where the servicer again says, please cure this default, and the borrowers did so. So to claim that that default is revived now years later to extend liability is improper. With respect to their reliance on the revised loan commitment, I think that is quite clearly parole evidence. If you look at these loan documents, every single one of them has an integration clause that precludes, that makes it the final agreement. If you look at the definition of loan documents in the deed of trust, which is item 15, Exhibit E, you'll see that it defines loan documents as documents signed at the closing or in the future. It doesn't involve documents predating the closing, and the revised loan commitment is a document that predates the closing. But even if you use the revised loan commitment and its description of loan months, it still says a default that occurs within the first 60 loan months. That's not inconsistent with our position and interpretation on the personal guarantee, that it was for payment of the installments and not the final payment. So even if you were to consider the revised loan commitment, it doesn't conflict with the requirements set forth by the plain language of the guarantee, and to the extent it is ambiguous and requires construction, again, it would be to limit the liability of the guarantor.
All right, thank you, counsel. We'll take this matter under advisement and issue a decision in due course. Court's in recess.
Brian, good job. I always feel the same good game after one of these things.
Yeah, it's an interesting experience.